Hello and welcome to the Arbitration Conversation. So in this arbitration conversation, we're going to talk to a real leader in commercial international arbitration. She has been doing amazing work for a very long time. I've been following her work for a very long time. I'm so pleased to say thank you, Catherine Rogers, for being part of the Arbitration Conversation.
Well, I'm delighted to be here. Thank you for inviting me.
So first of all, just a little bit of background. She is a professor at Bocconi University in Italy, but she also has a joint appointment at University College London, and she is the CEO and the founder of Arbitrator Intelligence, which is what we're going to be talking about today. And I'm very excited. There's so much more background. She's also an ALI reporter. She's an amazing professor. I could talk about that for a million hours, but today we're going to focus on Arbitrator Intelligence. So Catherine, first of all, I guess I would like to hear, what made you even come up with this idea of Arbitrator Intelligence?
So it didn't, the name Arbitrator Intelligence came much later. It originally started with my academic research. I focus on what's might be called either ethics or the professional conduct of different actors in international arbitration, and in particular, the market for arbitrator services. And it's a highly dysfunctional market characterized by high barriers to entry and information asymmetries, meaning most of what you would want to know about an arbitrator's track record is secret. And this creates a number of distortions in the market, including almost monopolistic-like characteristics in the sense it's harder to grow the market if there's not a lot of information. And as we're seeing more and more, also barriers to diversification in the pool of arbitrators. You can't add diverse new arbitrators if you don't know very much about them. So I saw information. The other problem with lack of information is, and information asymmetries, is it creates an uneven playing field. And that was actually really my point of entry, which is if you're a big multinational law firm or corporation, the way information about arbitrators is currently collected is you send out an email to your professional network. If you're a big law firm, big corporation with a big track record, right? You have a huge network you can ask for information from. But one of the other obstacles to diversity is, international arbitrators come or have some sort of relationship to parties and counsel from outside the United States and Europe. If those law firms in those jurisdictions can't effectively compete in getting arbitration business, I think that's unfair. And they might be the ones more likely to appoint, for example, diverse arbitrators. So the lack of information had a number of implications both for the market of arbitrators, for the fairness as between parties and counsel, and in terms of shaping the market for legal services in international arbitration. And so then I started thinking, how do you solve this problem? And how do you make information that's treated as confidential accessible to everyone? And so that's the problem I started with.
Right. Well, and I remember even talking with you over dinner many years ago about sort of the research project and gathering the information. Maybe talking a little bit about your sort of the interviews and the process in terms of your research.
Yeah, so we started many years ago. The article that prompted this all was 2005. I think we started getting serious about, more organized project in 2014, and the name Arbitrator Intelligence developed in 2017 as a nonprofit, and then we became a legal tech startup in the summer of 2019. But the original idea was as a research project to kind of, the problem was, if the problem's information, that's what researchers do, is they collect information. And so that was our original initiative. And we started collecting awards and different sources of information. And our ultimate, I think, innovation, the biggest innovation we have, is we developed an online platform that allows parties and counsel at the end of an arbitration to submit detailed information about what happened in the arbitration, but without revealing the parties' names or other confidential information. And so you can think of our platform, which is essentially an online survey, the Arbitrator Intelligence Questionnaire, 8IQ, as we like to call it. You can think of it as kind of playing a similar role to the app for Uber or for Airbnb. Like, they connect riders and drivers and people who need accommodations and people who have accommodations. We connect people who need information with people who have that information. And we allow, through our platform, them to exchange that information anonymously and confidentially. And what that means is the smaller but super, sophisticated boutique in Peru that doesn't have quite the same network as the global law firms, can nevertheless then access this kind of large aggregated base of information that's otherwise unavailable. And the other piece, which again, I think is really inspired by more academic background, is that we provide some very nuanced, sophisticated analytics. So it's one thing to have information about arbitrators. It's another thing to understand how to evaluate it. And so we provide what it has not only been us, but by others called sort of a rough equivalent to what's available now in judicial analytics. So in domestic litigation, judicial analytics is changing the way practitioners prepare for hearings. You don't just prepare your arguments and what you think are the best cases and respond to your opponents, but you look at the judge's perspective. What has that judge in the past ruled on this kind of motion? How often have they cited this case or rejected citations to this case? And based on those kinds of insights, you can much better either strategically prepare your case, or, for example, give your client a heads up that maybe this isn't something they're going to win, but you can just be much more sophisticated and nuanced. And so what we've done is we take the information we gather through our online platform and all the publicly available cases and information, and we distill those into analytics that enable parties and counsel to very quickly understand, get a sort of analytic profile of an arbitrator that otherwise you cannot get just by ad hoc research.
Right. No, that's really interesting. And certainly with sort of information and how it's out there, and we know about Revel, and we know about different Ross intelligence that happens with the courts. And so to see this in arbitration is actually really interesting. So sort of diving more deeply and thinking about kind of that transition from being just a nonprofit to now actually being a legal tech startup. I guess I'm curious now, how does it work as a now legal tech startup? Is it an SAS, or how is it sort of being developed in terms of a product?
Yeah, so to be honest, since it's an interview, I'll say this, it's been both an incredible personal journey and transition, as well as a sort of professional one. So one of my biggest personal challenges, and also for the company, was we, as proof of concept, collected, focused on Latin America, but a lot of data on cases as a nonprofit, and driven by our nonprofit message and our nonprofit mission, which was to promote transparency, accountability of arbitrators, right? Because if there's no information about how you performed in the past, you have very little accountability. That's one thing that a market of information does. And then again, diversity, because I really do personally believe more information is tied to greater diversity. And that was our mission as a nonprofit. My big concern was when we transferred and evolved into a legal tech startup, which we had to do for pragmatic reasons. We were not really eligible to get nonprofit style funding, so we had to turn to outside investors to get funding to be able to scale up. And my concern was that in that transition, we might somehow, if not actually lose it internally, because we're very committed internally to maintaining our mission, that we might be perceived as something other than, doing something that requires collective support from all the stakeholders, right? That's how we're going to be successful, is collective support from all the stakeholders, which is a little unusual for a commercial company. So we wanted to make the transition, but keep that. And I think the best sign that we have made that transition, although we, again, work on it every single day, is that we have about 125-ish ambassadors from all over the world, from Afghanistan to Zimbabwe, literally. And these are both, young and aspiring, and in many instances, very accomplished arbitration specialists who believe that for their arbitration practice to be successful, there needs to be this sort of combined commitment, to the commercial side, building your business, your practice, but also to these deeper goals that all eventually, I think, grow the pie for everyone, because they promote the greater legitimacy of international arbitration. They make arbitrator selection, more efficient. They make arbitrator outcomes more predictable. And those outcomes are good for everyone. Those things are good for everyone, both sort of, at a nonprofit, more kind of altruistic level, and as a practitioner. And so we have these amazing ambassadors that I think are committed to our larger goals, and that help us in so many different ways. And it's a volunteer team, but they help us in very concrete ways. And we think we also help them, because it's a sort of dialogue that we have with them about how to get better and do better. And And we also create opportunities through their participation in our project to raise their profile, to engage in activities that they're interested in, to engage in scholarly research facilitated by some of our activities. So,
Oh, that's
I think that they're the best sign that we've kind of successfully made that transition.
So important. No, I love that. And I would agree with you tremendously in terms of transparency for a number of reasons, both altruistic and on market in terms of promoting efficient market that has the information necessary. So it's really important. And when you sort of think about the analytics, and then also when you think about kind of the specifics of the information that's being obtained, is there any kind of interesting revelations that have come to light that you've seen since beginning this project that maybe you didn't expect?
Yeah, I couldn't have paid you to ask a better question, because what we are finding out is fascinating. So we are still collecting a lot of data. So we don't have what I would call big reports on lots and lots of arbitrators, but on the once you get a sizable number of cases, you see patterns. And we use, when we're searching for arbitrators now, we use these kind of proxies or shortcuts. Oh, it's an arbitrator from a civil law jurisdiction with this, training, so they're probably going to do narrow document production, or have less likely to shift costs and fees. And we are seeing that arbitrators from similar, from the same jurisdiction with similar educational backgrounds have oftentimes distinctively different patterns, which of course you expect. In the U.S. court judges, we know that they have different patterns, but for some reason in international arbitration, we use these kind of backgrounds as shortcuts. And so we are seeing, number one, that there are very discernible differences, for example, in rates of recovery. In informal casual research, you cannot calculate the average rate of recovery. Is this an arbitrator who tends to give more to claimants than the average, or less to claimants? And we are seeing arbitrators there are differences. Now, these are track records, so they're aggregated. It doesn't say what's going to happen in a particular case, but you would want to know before, if you're a claimant or counsel for a claimant, and you advise your client to pick this arbitrator, you'd want to know that they actually tend to provide for claimants, less than 40% of the amount requested, which is significantly less than the average in similar cases. And we can see that in the data, and those are the kinds of trends you cannot see outside. And another example, we are seeing very significant differences in the amount of time it takes for arbitrators to render awards, including, some that might, for example, have a bad history, or a couple cases that took a long time that are public and well known. But what you don't see is actually that they have a long track record of cases that were timely. And I think one of the signs we are seeing in the data is we measure both from the beginning to the end of the case time, and from the close of proceedings to the issuance of the award. So we can see how long did it take deliberations and issuance of an award. And particularly for the chairpersons in the case, it's a really good sign. If even in a big and complicated case, they can get the award published, presented, finalized, and presented to the parties quickly. So we're seeing a lot of incredibly valuable insights. One of the things I'm really excited to do as we round out some of our data is also to issue more data across the board. For example, one of the fascinating things, do cases that are bifurcated or trifurcated take longer or shorter? I mean, the bifurcation, trifurcation, I mean, part of the drive for those processes is efficiency. But interestingly enough, we're seeing that maybe that's not exactly what happens. Is these bifurcated, trifurcated cases, or dissenting opinions. The opinion, the intuition is, wow, that must mean a case that's going to take a lot longer when you have one arbitrator who's in disagreement. We're finding the period for drafting the awards does take, statistically longer, okay? But interestingly enough, there's not a huge difference in the overall length of the case, which could mean a couple different things. Could mean a very effective chairperson who's good at corralling even disagreeing co-arbitrators. It could mean that the disagreement arises later, and we can't really see that in the data. But there are a number of trends and ideas you can get about cases when you see this aggregated data. And we also have, I would say, some really exciting analytics on investment cases. And once again, those are sort of inspired by my academic background, doing empirical analysis in academic fields, and looking at how these empirics have educated debates about investment arbitration generally, but historically have not been broken down by arbitrator. So you could kind of use those same insights in your arbitrator selection and case strategy planning.
Yeah. Well, and I am curious, one other thing, of course, that comes to mind whenever you talk about reviews, what do you do, or do you see some sort of abusive reviews, or perhaps you get sort of the individual as sour grapes, and what's the process essentially for gatekeeper, right? So that
Yeah.
you don't sort of allow for kind of arbitrator bashing to
Yeah,
occur.
well, first of all, we already see this, for example, in arbitrator challenges and attempted, lawsuits despite, arbitrator immunity. And those are designed to protect arbitrators from unfair bashing. On the other hand, feedback is really a healthy part of improving your whatever you do, whatever job you have, except an arbitrator, usually involves feedback. But we're very sensitive to the need to be responsible and respectful in feedback, so we have internal policies if we can for identifying and characterizing something as abusive feedback or unduly abusive feedback. Most of our feedback, though, is highly structured, and we also, to be honest, we are not seeing a lot of arbitrator bashing. What we are seeing is thoughtful responses to very specific questions, and the questions in some ways themselves, the structure of them corral the feedback. And then we have internal editorial policies for that. And the other thing that we can do is through the analytics. So one of the most important questions we ask is basically the parties to self-identify. The person who fills out the AIQ to self-identify as a winning or losing party. We don't ask it winning or losing. We say, was the award more favorable, less favorable, as expected? Because that nobody's going to check a box saying, yeah, I lost, right? Okay, so but they do tell us honestly whether they think the award was more favorable or disappointing, and then you can filter their other evaluative data by whether they won or lost. So we just announced our Arbitrators of the Year, and the criteria we used for Arbitrators of the Year and kind of distinguished arbitrators was: did a losing party, a party who self-identified as being disappointed in the award, nevertheless give the arbitrator favorable feedback? In many ways, that's the highest recommendation you can have as an arbitrator, right? When the party who lost says your award was well written and balanced, persuasively written. When they say that notwithstanding the fact that they lost, they think you as the arbitrator asked intelligent questions that showed you were really prepared at the hearings, or whether your procedural rulings on your tribunal promoted fairness, promoted efficiency, even though they lost.
Oh, yeah.
Those are some big concessions by a losing party. And so we have both evaluative data, but it's limited and targeted to keep it fair. And then we can also use that to filter some of the other more quantitative data. So as an example, we ask for document production. Was it requested? If so, by whom? Was it granted? What standard was granted? We can use that. We can evaluate that in terms of size of case or industry, but we also ask an evaluative question. Do you think the document production was kind of too much, too little, or just about right? And then based on their evaluations of the document production, we can also filter that by whether they were a winning or losing party. And so you can kind of, with enough data, you can start triangulating to see patterns and data analytics can never tell you causation, but it can give you theories about what insights, ideas about what you think might be inspiring certain trends. And those are really, I think, incredibly valuable to parties and counsel.
Yeah,
and we're finding them fascinating.
No, I think I love data. I mean, I just think and transparency is so important, especially in arbitration that has had, a bad rap for lack of transparency. So this project is really welcome to all of us who study the area. And I just think it's really fantastic. And for those who want to learn more, could you sort of direct the listeners to where they can find out more about Arbitrator Intelligence?
Yeah, so arbitratororintelligence.com is our website, and you can find out a lot about our reports there and our Arbitrator Intelligence questionnaire. If you're someone who's recently completed an international arbitration, please go fill out an AIQ. You can have someone junior who has the file fill out phase 1, which is the names, dates, facts, and all that, and then phase 2, which is the more evaluative part. Takes 5 to 7 minutes. If you do it, we'll give you $1,000 credit towards purchase of reports. We have reports today on over 300 arbitrators from around the world. In addition, we welcome you to follow us on LinkedIn or Twitter. We have a lot of interesting posts on LinkedIn, including most recently you would have seen revealed who our Arbitrators of the Year are, and we're coming up to announce a number of our distinguished arbitrators. So that's where you'd find us.
Oh, very nice. I know I'm following you on LinkedIn, so I'm looking forward. Hey, Catherine, thank you. I could talk to you all day. I know you're busy, but this has been really informative and helpful, and I'm just very thankful to have this time with you.
Oh, it's been really fun. Thank you so much, Amy, for having us and for having me. And always good to talk to you next time again over dinner sometime.
Oh, 100% in Paris would be nice as well.
Or Milan. Okay.
Or Milan. Thank you so much.
All righty. You take care. Bye-bye.